Viewers, welcome to the Personal Injury Law Show. My name's Tony Carbone. I'm a personal injury lawyer of over 25 years experience. With me tonight I've got John Organiser, who's an expert in workers' comp work cover claims. Good evening, John.
Hi, Tony. Hi, viewers.
And also a partner in a law firm that deals with insurance public liability claims, Nunzio, Tartaglia.
Tony, John, viewers, welcome.
Tony, what's in the news this week?
We've had a lot of stories in the news, viewers, and this is something that we do want you to go to Twitter, Facebook, give us your comments as we go. This is a story of the class action involving AusNet. Is that the
ISP AusNet?
And also the cable that came down, started the bushfires that spread out to King Lake and...
Tony, February 2009, we'll all remember that Saturday. It's a Black Saturday. It was...
119 deaths.
119 deaths, devastation. You and I saw the region straight after the bushfires. It's black, it was all burned.
Well, I was there 4 or 5 days later just volunteering my services, John.
Likewise, yes.
Nunz, what do you think is going to happen here? Robert Richter opened the case for...
Well, Tony, about that, Robert Richter QC, a well-known criminal lawyer in a common law case. What's the Victorian common law bar would be quite a... It's unusual.
He's a very technical barrister, so I think there could be a bit of evidence along those lines, engineering and that sort of stuff, John. That's why I think they brought him in.
Justice Jack Forrest is presiding. It's judge alone. This is listed for a whole year, Tony, nearly.
Yeah, look, there's a lot of witnesses. Not over 150 witnesses.
Yeah, look, it's going to go for the remainder of the year, and barristers at the bar have been engaged for the whole year, so it's a full-time gig in itself. And it's a $1 billion class action, and look, we're going to be talking about class actions in the episodes to come, but it's a huge, huge matter.
Well,
and, look, where this leads, it's going to be really interesting.
And Tony, on my understand, the plaintiff claims that as a result of basically not inspecting this particular conductor...
Power pole, yeah.
A conductor that was on a power pole, the lightning struck it and caused this whole firestorm.
Well, there's a number of parties involved, isn't there?
Yeah, look, there's a few parties. You've got the SPI, electricity, but then you also got the Department of Sustainability, you've got the Victoria Police, the CFA.
We've got the contract that it was supposed to inspect the poles.
Yeah, look, there's a numerous amount of parties, and to lay blame on all those is going to be a tough task.
The claim is based on negligence.
Yes.
That basically the defendant, as in ISP AusNet, and the contractors, did not perform their required duties in inspecting and maintaining the conductor and power pole. Well, but, Tony, there's a problem here, isn't there?
What's that?
The defendants say this is an act of God. Lightning struck this power pole. How are we supposed to stop that?
No, it's just on that point there. Robert Richter did open and say that there were certain things they could have done to this power pole, a couple of gadgets they could have put in there that would have prevented the pole from catching on fire.
And if it was in better order and condition, it said even though you had it was just a natural disaster, that it could have been avoided anyway. So that's the evidence they're going to have to lead
It's
anyway.
a very interesting common law case, isn't it, Tony?
I think so.
It's got those classic tort principles of negligence and act of God. I mean...
But see, it wasn't the actual lightning strike that brought the pole down. It's that they failed to add these other pieces of equipment that would have kept the pole up. That's what the argument's all about, John.
Well...
Because it was a very long stretch of power line that went for over 1 kilometre, and they said that when you're dealing with those sorts of scenarios, you need to put in extra preventative measures, Nunz. Yeah. Is that your understanding?
Yeah, look, that's part of it. Now, look, there's going to be a raft of, I suppose, complexities in this case about what happened, how it happened, and look, it's going for a year, so there's going to be a lot on it.
How does the plaintiff get around the fact that this pole was inspected 1 year before the bushfire?
Well, I don't think that helps. I think that helps the plaintiff.
Really?
Yeah, I agree with Nunz on that one, John.
Ooh.
Because
we're not talking. Sorry, we're not talking just a footpath here where you might have a little displacement. We're talking here electricity, things that can cause massive damage. So you need to have an ongoing maintenance.
So what about if the evidence is it was inspected 1 year before the bushfire and the contractor gave it a big tick saying it's all okay?
Well, Johnson didn't do their job properly. That's basically what Nunzio's saying.
But also, they're saying it's 43 years old conductor. So it may to be that old enough now that need to replace. We don't know.
Look, we'll come back to this story because it's going to unfold in the next weeks and months. Viewers, follow us on Twitter on this one because I do want to know your views. And just before we do that, assuming there was a jury in this case, what would happen there?
Well, Tony, at the moment it's judge alone and it's estimated for 10 months for a trial. The problem is with a jury, it'll be estimated for about 2 years.
At least.
And it's a disaster for the whole legal system.
And Nunzio, do you believe a jury would have the understanding and sophistication to be able to...
Look, unfortunately, the case of this size, complexity and that many issues involved and the quantum itself, I don't think it's suitable for jury.
Also on the issue of fires and things like that, tell us about this burnt runner that's suing John in the ultra marathon run.
Tony, this happened now a few years ago, and we've seen this lady on TV. Horrific burns to the point where the doctors told her she was going to die. She was performing in this ultra marathon, and the organisers, the evidence is, ignored the signs and warnings that there's a firestorm coming down, and basically the race continued. She's been burnt to almost her death. Now mediation has failed. The organisers, Tony, unbelievable. They refused to pay all medical expenses.
It's outrageous, isn't it? What's her claim all about, Nunz? What's it worth?
Look, it said I think she's got 64% of burns to her body, and I think she's lost her fingers. Look, it's big money, and look, the reality is I'm stunned at Racing the Planet don't even want to offer to pay her medical bills, and look, this is going to be litigated. There's no doubt about that. So
it's worth millions of dollars.
And look,
isn't it?
I think the commission have done a report on this, so the evidence has already been established. So I find
if it was in Victoria, what's her pain and suffering worth? She was a very attractive young lady, 25-year-old.
The maximum in Victoria is 371,000.
And you'd hazard to guess she'd get that, wouldn't she?
Oh, look, she's going to have to be up there.
It's not a lot of money, is it, Tony?
No, it's not. But I'd imagine she'd get the maximum.
Yeah.
But what about loss of income? What's she worth there, Nunz?
Well, look, I'm not sure exactly what she was doing for income, but being 25, the fact is she probably can't work for the rest of her life. Look, she's worth in the millions, but look, there is a cap on loss of earnings, but she's worth a lot of money, Tony.
Okay, let's keep moving. There's a gardener who sued and got $130,000 from a judge when the coppers belted him, John.
Tony, this is a great case. It's a classic case where the public Joe Blow has been bashed by the police. The authority has really taken, for some reason or another, has taken against him. Judge O'Neill of the County Court of Victoria has awarded him $130,000 for pain and suffering damages, and on top of that, found the evidence of the police officers had no credibility, Tony. This is outstanding. It's an outstanding result.
And Nunz, it was a case of this fellow lunging at the police officer and then a police officer overreacting.
Yeah, look, there's a bit of background. He was arrested for drunkenness and obviously was in the cell, and then obviously lunged at the police officer, and then the police officer belted him. He gave evidence he thought he was going for his gun, but Judge O'Neill didn't believe that, and hence why he's received a favourable judgment. Viewers,
we've got to go to a sponsors break. John, thanks for coming on board.
Thank you.
Follow us on Twitter and Facebook. And after the break, we're going to be talking about exclusion clauses in recreational activities and public liability. So please stay tuned.